Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello. You're welcome to today's edition of Hanging Out with BWF Solicitors. My name is Vicky Newton. I'm going to be your host for today's show. This show is organized and sponsored by BWF Solicitors. If you've just joined us and you don't know who BWF Solicitors are, they are a law firm. They specialize in family law, immigration and nationality, Ghana law and practice, dispute resolution, and many more. So we are here today to talk about immigration. Today's topic is, how do I acquire British citizenship if I was born after 1983 and at least one of my parents is British? With me today is Mrs. Eunice Achampong. She's a partner at BWF Solicitors. She'll be taking us through this topic, and we'll also be discussing the steps one has to take in regards to this topic. You can watch us live on YouTube and Facebook at BWF Solicitors and Vicky Newton. Lawyer Eunice, you are welcome to today's show.
Thank you so much. How are you?
I'm good. And you?
I'm doing well by God's grace. It's good to see each other again.
Yes. Before we start today's show, as we always do, you do take us through what is happening, in regards to immigration, for our viewers to keep abreast with what is going on, because most of them don't know where to get the latest information from. So with you on this platform today, at least they will be able to know what is really going on. So over to you.
Thank you so much. And so I send my hellos and good mornings and good afternoons to our viewers watching us, whether it's on YouTube, Facebook, wherever you're watching us. I hope you're doing well, and by God's grace, everything is going well with you. As Vicky has just mentioned, we usually give an update as to what is going on with our UK immigration laws and how you can keep abreast with them. So, first thing first, I would like to say that when it comes to our immigration rules, obviously the government have found ways to make it more simplified after Brexit occurred in 2020. So it became more important that as lawyers, we also make sure that we are also abreast with whatever is going on. One of the guidances or policy changes that have come through is in regards to those of us who have children we brought from outside of the UK who still have their national passports. And if you have indefinite leave to remain and you have a national passport which is not British, so you have other passports but not a British passport, you are still seen as a foreigner or somebody who is an immigrant. And as under our UK Borders Act, if a person commits a crime for which they are convicted, then that person will have to receive a deportation order if the conviction was for 12 months or more. The reason that is because they do not want to tolerate, obviously, bad behavior and those that are going to put the British reputation into disrepute. So, of course, if you have committed crimes for which they believe that those crimes are very grievous and are not consistent with those that are law abiding citizens, then they can say that you can return to your country of origin because you have been sentenced to at least a period of 12 months or more. And if you are sentenced, they are saying that you have no right to appeal if it's certified. So you can appeal only if they've deported you. That was something that was there before, and then the rules changed where they said they will obviously consider these um, claims for human rights whilst the person has the right to appeal within the UK. And they've come back with the rule that you can obviously appeal later after the deportation has taken place. So there's the general rule now that if your claim for human rights is certified because you've received a deportation order, then they can deport you first and then you can appeal later. Unfortunately, that's not helpful for people who haven't been to their country of origin for many years and would not even have contact with other family members outside of the UK, because most of these young people, they come and make their life here in the UK. Most of them hardly go back home, and it might be that they don't even speak the language that their parents speak. So, unfortunately, for them to go back home to a country where they were born in, unfortunately, they would not have the same support system they used to have when they were there as children. And so, to them, it is taking them back to an obscure place. And a lot of our young people who are caught up in these situations where they have been given deportation orders now have to fall back on the fact that their human rights claim will be strong enough such that it will not warrant them being deported first and then appeal later.
Okay.
Because if the Home Office believes that you've made a human rights claim, maybe you are saying that you had a partner whilst you are at prison and now you are out of prison, your relationship is continuing. To them, the relationship was only formed whilst your leave was precarious, because once they believe that you are trying to circumvent the law in terms of you trying to gain some ground in remaining in the UK, they would see that as clearly unfounded. And so, if your human rights claim, whether it's based on your spouse, your partner, your child, is seen to be unfounded, they have a right to say that they are certifying that claim because they don't think that your claim under the Human Rights Act or your Article 8 claim is founded.
Okay.
So, under our immigration rules, you will see that under paragraph 335 that when it comes to you making that claim based on your family life, they will consider whether it will be unduly harsh for you to go back to your country of origin, and whether your spouse or your child who is British will obviously find it unduly harsh because of the fact that they are probably going through some form of illness, or they are probably going through some form of condition that will make it very difficult for them to have you removed from the UK. So when it comes to unduly harsh, there isn't really a definition for it, but they want to see that it will be so harsh that it will have a detrimental effect on your spouse or your child who you are leaving behind. And so most of the time, if your spouse or your partner or your child is okay, and
Mm.
you can communicate by video link, you can communicate by phone, then it will not be seen to be unduly harsh for you to return back to your country of origin, because there are other forms of communication that can take place if you were taken or deported from the UK. And it's very high threshold. So to say that it will be unduly harsh means that you really have to show that the impact and the detriment it will have on your partner, it will have on your child, is such that because maybe they are going through a certain illness or they have a certain condition, if they don't get the support, the necessary support that you provide to them on a daily basis, or you provide to them regularly, they will not be able to cope. And so they have to look at all of these circumstances when they are considering your claim for human rights. Um, it's very obvious that a lot of people will try and rely on their rights to family life or their rights to private life in situations like this. But unfortunately, if you are just dependent on your private life, it does not provide a very strong basis for them
Basis.
to, yes,
Mm.
to obviously keep you here. They can easily deport you if you have no family life whatsoever, because it means that you haven't really got strong ties that keep you here in the
Yes.
UK. So
Mm.
it's very likely that they are able to say, well, we believe that because you have no spouse or partner or child, therefore you don't meet the requirements and the exceptions to the rule, and therefore we can deport you and then you can appeal later. And I know that a lot of our young people before even the COVID were in situations like this where they would have been deported and they wouldn't have the means of coming back. So they would go ahead with the appeal because they will have representatives here who would
Mm.
obviously deal with the matter. But unfortunately, they wouldn't be able to come back because most of the time they wouldn't have the means to really defend themselves. And so the case will be dismissed, and that would mean that they will have no means to return to the UK. And so it makes it quite difficult for them once they've been deported to really try and return to the UK, because, of course, that means that the automatic ban of 10 years will apply as well. So we need to really, really keep our kids grounded, because even if they do apply for British citizenship after the required period of time, also know that if the crime that they've committed is so grievous, or they have been known to have gone through the British citizenship application through any form of deceit or not disclosing any
Mm.
relevant information, that too could also cause them to be deprived of their British citizenship. So, yes, they have their indefinite leave to remain, but as much as we will advocate for them to be British, they should also be well grounded in society such that they don't fall into the wrong hands. Because once that trend starts, it's very difficult for them to come out of it. And then, unfortunately, you will find that they are convicted of crimes that obviously they didn't expect to uh,
Okay.
get into, and therefore it creates that domino effect where they are always being sent back home. So I think that we should keep note of this, and as much as we are lawyers, we want our young people to be aware, and we want
Okay.
them to be responsible, and we want them to also be grounded in society so that they don't fall foul to these rules that are in
Mm.
place.
Mm. Mm.
And then,
Mm.
secondly, when it comes to, I know our applications, a lot of people within the UK would want a much quicker decision, and so they prefer to go through the super priority route or through the priority route. Of course, those priority services are available if you are within the UK and you are making an application and you want the application to be expedited. Once you have put in the application, know that you will have the option to pay for the priority service whilst paying for the application fee. And so the
Okay.
two can be done together. Instead of choosing a standard service, you
Mm.
choose that super priority service in order for your application to be processed within 24 hours of them receiving your biometrics and documents. So most of the time, your biometric appointment is where documents will be uploaded and sent off to the Home Office. And so after such time, they have 24 hours in which to process your application and make a decision on your application as quickly as possible. And so they have that service available, but it is not, should I say, regular. So if
Okay.
for some reason you don't see it whilst paying for your application, hold on if you have some time, and then make sure that as much as possible you are going to refresh your screen after midnight, because they do refresh it after midnight,
After midnight. Okay.
and you can check again to see if the priority service is available once again.
Mhm.
Yes.
Mm.
When it comes to the biometric cards as well, because a lot of people are wondering why the biometric card is saying or is stating an expiry date of 31st December 2024. So if for any reason you have a biometric card because you've applied for leave, and you
Mhm.
know that your leave is supposed to be for 2 years, or your leave is supposed to be for 2.5 years, or your leave is supposed to be for 3 years, and you are wondering why your biometric card is stating 31st December 2024, which is just next year. That is because the British government have said they are going to digitize everything. And so we will no longer be receiving those biometric cards. They will no longer issue out biometric cards. So if you have a biometric card and you are thinking, well, the expiry date on there is wrong, it is correct. It is because the government will now have your leave on their online platform, and those who would want their right to check to work checked, their right to rent checked, their right to obviously open an account checked. All of those things will now be done online. Even if you were to travel, because of course you will have your passport with you, the immigration officers at the standpoint will be able to check that you have the right immigration status to re-enter the UK. So don't be worried if you see the 31st of December on your biometric card. It is only because they are now going to digitize everything so that they will no longer need that biometric card that you are holding at the moment. So that is also something that I want our viewers to be very much aware of. And then last but not least, when it comes to our EU nationals and those family members who are living within the UK, I always say that it's important that you always check um, what time, for instance, this person became a family member,
Yeah.
because there are certain applications that can be done under the EU route, and then there are certain applications that have to be done under the family life route. So if you are an EU national and you are trying to bring your wife, your husband, your partner from outside the UK, then please make sure that you are including evidence of the fact that your relationship started before December 2020. If you are not able to provide evidence as such, it will be very difficult for the caseworker to put into play that your relationship is a genuine one, because they would think that for the purposes of Appendix EU, you have to establish that your relationship began before the specified date of 31st December 2020. So make sure that you have evidence that is suggesting that your relationship is indeed one that began before such time. So if you are married, then you were married before 31st December 2020. If you are partners, you were partners for 2 years before 31st December 2020. They want to see that form of evidence of communication, of that relationship being genuine, before you do make that application to bring that family member. If it's a child, and of course the child was born to you, and your partner who you've been with before the specified date of 31st December 2020, and of course you want to bring that child, you can still bring that child along. So you as an EU national can still bring your spouse and your child under the EU route, as long as it was before December 2020. If you have recently met the person, and let's say the relationship began in 2021, then you have Appendix FM family route, under which you would be able to bring those family members, whether it's a spouse or a child, whoever is a grandparent or a parent, can
Mhm.
also apply if the relationship was after 31st December 2020. But if it was before then, because most parents and grandparents were, you were born to them before that time. So definitely you can bring them under the EU route or Appendix EU based on your relationship as a child or as a parent or as a um, grandparent of that grandchild. So I'll leave the updates here and then we can continue.
All right. In regards to the updates, what if you misplace your card?
Mm.
They are
So
not going
you,
to replace them because they are facing it out.
if you do want to replace it now, you can obviously ask for replacement because they will replace it as we are within now and the transition period. So they've said we should give them up to December 2024 so that they
Okay.
can phase things out. So
Out.
if you want a replacement card, definitely you can apply for one, but it's just that it will end by 31st December
Okay.
2024.
Okay. All right. Thank you. Right, ladies and gentlemen, that was lawyer Unisa Champon giving us the updates. If you've just joined us, this is Hanging Out with BWF Solicitors. I'm your host, Vicky Newton. Today's topic is, how do I acquire British citizenship if I was born after 1983 and at least one of my parents is British? Lawyer Eunice is going to take us through this topic. I'll also like us to be engaging. I will expect you viewers to send in your questions so that Lawyer Eunice will answer those questions for you. Right, Lawyer Eunice, who is entitled British citizenship on or after January 1983?
So, our British Nationality Act of 1981 is very broad in the sense that we had various British Nationality Acts before then. And it is broad in the sense that it made a lot of changes in terms of those that become British citizens in the UK.
Yeah.
So you would realize that even though it's called the British Nationality Act of 1981, it didn't really come into force until January of 1983. So on the 1st of January 1983 is when the act came into force or when we started to apply the act. And before then, I would say that a lot of people who were born here in the UK would have automatically received British citizenship just
Okay.
because they were born here in the UK. But because of the British Nationality Act of 1981, unfortunately, that automatic right to British citizenship by birth um, was phased out. And so most children who were born in the UK could no longer be British just by birth. They had to um, basically derive their citizenship from their parents. So if a parent of theirs was either British or settled in the UK at the time of their birth, then under Section 1, they would also be British because their parent was a British citizen or settled person at the time of their birth. If neither parent was British or neither parent had indefinite leave to remain, then that meant that the child would have had to live here for at least the first 10 years of their life. So if the child had lived here for the first 10 years of their life, then they could register. So now you're not saying they are automatically. Now they will have
Okay.
to register to receive their British citizenship before they apply for passport as a British citizen. So because they had lived here for the first 10 years of their life, they would have to then apply for British citizenship before they could apply for their passports.
Okay.
And
So, Lawyer Eunice, is that the same as naturalizing, getting a
well,
naturalization certificate?
That's for those who are adults. So for adults, we say
Okay. Okay.
naturalization,
All
and
right.
for
Okay.
children, we say
Okay.
registration. So
Wonderful.
that's the difference. I
Okay.
know a lot of adults who have naturalized who will tell you that they
Yeah.
naturalized, and so for children, they call it a registration, rather than naturalization because they're still children. So in that sense, the child will have to be registered before they become British. And um, let's just remember that we are from a very um, should I say, previous to recent years, we're a very Christian country, and so a lot of the rules were to do with married couples. So a lot of the time, they would expect that if the couple were married, then of course, automatically that child will be British because one of their parents was settled or British
Yeah.
at the time. But if it were the case that the child's parents were not British or the child's parents were not married, then it would mean that, of course, like I said, the child will have to register. But if the child's parents were not married, but at least one of them was British, then that would mean that the child will also have to register because their parents were not married at the time of their birth. So
All
it
right.
means the child will have to register to be British. They will take documents from both parents to
Mm.
see if indeed this child deserves to be granted British citizenship. Both parents will have to consent to it before this child will be granted registration as a British citizen, and then they can apply for their passport. So I believe our laws are very traditional in that sense as well. Yes. And you would find that if parents were married and then had children out of wedlock as well, they would definitely say that the child who was born at the time will still derive their citizenship from the parent that their mother was married to
Good.
at the time of
Mm.
their birth and not the biological father. So our laws are very traditional still in that sense. Yeah, so
Oh,
those are the people who are eligible for British citizenship.
okay. All right. Can a person born outside the UK be automatically British?
So usually, um, those who are born outside of the UK, you will definitely have to meet certain requirements, especially under our British Nationality Act.
Mm. Mm.
So let's say that you've had a child outside of the UK and the child was born to you in 1983. Once that child was born from the 1st of January 1983, the law under Section 2 of the British Nationality Act states that the child's parent must have been British at the time of the child's birth and not by descent. So, what that means is that the parent of the child must have naturalized to become a British citizen, and therefore they can pass on their citizenship if they have a child outside of the UK. So
Mm.
if, let's say, I was born in the UK and my mother was a British citizen, I derived my citizenship because my mother was British. If I go and have a child outside of the UK, my child will not be British because it means I will be passing on my British citizenship by descent. And unfortunately, the law doesn't allow it to be like that.
Okay.
So it is only those who have received British citizenship not by descent. So most people who receive it through registration or naturalization did not receive it by descent. Most of the time, if you have naturalized as a British citizen, then it means that you did not derive it from anybody. And therefore, if you have a child outside of the UK, then that child will be automatically British if at the time the child was born, you were British.
Okay.
So those who are outside of the UK can only derive it if their parent was British at the time of their birth. That
Hmm.
is only if they were born after 1st January 19.
Hmm.
Yeah.
Right, ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors, with your host, Vicky Newton. Our guest is Mrs. Eunice Achampong, a solicitor at BWF Solicitors, and she's also a partner at BWF Solicitors. Today's topic is, how do I acquire British citizenship if I was born after 1983 and at least one of my parents is British? So Lawyer Eunice has taken us through who is entitled to become a British citizenship after January 1983. Please share this program so that other people will also benefit from this program. We will also love to hear from you as well. So we will be expecting your questions, and Lawyer Eunice will be very happy to answer those questions. So as I previously said, Lawyer Eunice is taking us through the steps and the do's and don'ts. So Lawyer Eunice, I've got Zainab. She is asking you, if my parents are not married, do I still obtain British citizenship automatically, or do I have to register to be British?
Okay, so if, for instance, like I was saying, our laws are very traditional in that sense of your parents being married for you to have British citizenship automatically.
Yeah.
So if your parents were not married and they were living separately, and it happens that one of your parent is British, so maybe your father is British, but unfortunately he wasn't married to your mother at the time of your birth, then it would mean that you will have to register um, to become British. So there's a UKM form for those who are deriving their citizenship from their mothers, and then there's the UKF form for those who are deriving their citizenship from their fathers. So if it is the case that your father was British and you are now acquiring British citizenship, then you will have to fill in that registration form, and then once they've given you your certificate as a British citizen, then you can apply for your passport. So if your parents are not married, then you would definitely have to register to be British before you can apply for your passport.
Okay. All right. Great. KK is also, KK says, good afternoon, Laura, Eunice, and Vicky. I'm really enjoying your program. I was born outside the UK to my mother, who was a Caucasian British citizen. She passed away a few years after she gave birth to me in Ghana. She had traveled back to the UK by then. She was not married to my father, and the only thing that I have of my mother are a few photographs that were taken when I was a baby. Can I claim to be British because my mom was British?
Okay. I like the fact that she's giving a bit more detail so that at least we can really delve into this question.
Yeah.
So, when it comes to our British citizenship, especially if you were born outside of the UK, she says that her mom was Caucasian. So, that means that very likely that her mom was a British citizen, and of course maybe it could be that she couldn't continue life in our hot tropical weather and therefore decided to return to the UK. Of course, if she was born in Ghana and she has evidence that her mom was British, then she can go ahead and then register to be British. So what happens is that you will have to prove that your mom was indeed British. And most of the time, if you don't have any evidence to prove, then it means that searches have to be done at the registries. With the UK, they have been keeping records of births and deaths for a very long time. So when you go to most councils and you want to do a search for a particular person, they will ask you to obviously pay a certain fee for them to try and retrieve the birth certificate of that particular person. So it's possible to try and retrieve such information. Um, as long as you are able to prove that indeed your mom was British, then you can go ahead and then do the registration. But it's, of course, it's one of those applications that I would say, because this mother of hers, if it comes up on the birth cert that she was British because her parents were also British as well. You remember I said that under section 2, you can
Mm-hmm.
only transfer it by non-descent. So if this mother derived it from her parent and therefore she's had her child outside of the UK, this child will now have to have some form of registration. And usually the best option will be to go through a right of abode.
Okay.
So usually people who are Commonwealth citizens. So Commonwealth includes a lot of African countries where the British colonized us, and Ghana happens to be one of those countries that we can say is part of the Commonwealth. And so, if she's able to prove that because she's part of the Commonwealth and one of her parents were British, therefore she's applying for a right of abode to be able to come and live in the UK, she will be able to gain a right of abode because she's a Commonwealth citizen and her parent was British at the time of her birth. So she will not be going directly under Section 2 because
Mm-hmm.
unfortunately her parent was British by descent, but she will be able to gain a right of abode because she's able to show that ancestry of British citizenship. So this will come under Section 4 and Section 11 of our British Nationality Act. So that will in turn help her get the right of abode, and then she can come and live here in the UK.
Okay. All right. Thank you, Lawyer Eunice. Keke, I hope you've understood the explanation Lawyer Eunice is giving you. If something is not very clear, Lawyer Eunice will leave her details at the end of the program, and you'll be able to contact her. She'll book an appointment with you, then probably find ways and means to help and support you. Right. Okay. The next question is coming from Nana. My wife and I had our daughter in January 2021. I'm Belgian national, and I was granted settled status under the EU settlement scheme in July 2021. Before that, I had permanent residence card in 2017. Would I have to register our daughter as British, or can I apply for a passport straight away?
Okay, so this is to do with an EU national.
Mm,
And let's be clear, when it comes to EU nationals, before Brexit occurred, they would usually have applied for residence card or um, permanent residence.
yeah.
So if an EU national was living here in the UK before 2020 and they had lived here for a period of over 5 years and they were qualified people, so qualified persons means that they were either working, they
Mm.
were self-employed, or they were self-sufficient with their own comprehensive sickness insurance, or they
Okay.
were here as a student and they had comprehensive sickness insurance. So if they are able to prove that they were qualified persons for at least 5 years of them living here, they would have been granted permanent residence.
Mm.
So in this person's case, she's been granted permanent residence, and they want to know, will my child be British? Well, you will have to prove that you had permanent residence, because the thing about the EU national is that because he has that EU passport, unfortunately, most of them did not apply for the permanent residence. Some assumed that because they've lived there for 5 years and they were working, automatically they've gained or they had a right to permanent residence. And
Mm.
that was the law at the time. It meant that because they had the right to permanent residence, um, because they've been able to show that 5 year qualifying period. Therefore, they didn't need to do anything else. It wasn't until we were introduced to the EU settlement scheme
Mm.
that a lot of them realized that even if they haven't done the EU settlement, I mean the permanent residence card, they would have to do this EU settlement scheme to be able to get their settled status. So if you have a child and you are saying to yourself, I had this child by the time I had my permanent residence card, then you will have to prove that you did have permanent residence at the time that this child was born.
Okay.
If you are unable to prove that you had permanent residence, then you would definitely need to have applied for the EU settlement scheme.
Mm.
And then once you've received settled status, then you can register the child to be British, and then the child will then be able to acquire British citizenship through registration, uh,
Mm.
and then of course apply for the passport then. So it's important that you are able to prove your permanent residence at the time. If not, it will mean that you will have to wait till you've done the EU settlement scheme before registering this child. But if it is the case that you can prove that you had permanent residence, then you can apply for the passport straight away.
Okay.
Yeah.
All right. Right. The next question, yes, it's from Anna. Hi, Anna. Yes, I have a son that was born in my home country who is now 3 years old. At the time he was born, I was British. I was a British citizen and was married to someone else who is not his father. The child is being looked after by his grandmother, and I now want to bring him to the UK because I'm now divorced from my husband. How do I go about it, Rahila? She says.
So this one is a very interesting one because she's saying that she was married, but she went to have a child outside of wedlock, and this child is not her husband's child, but now um, she wants to get a divorce. Well, in such a scenario, at the time that the child was born, usually they would ask if you were married. I remember one of my clients said to me, she went to the registry to go and register her child,
Mm-hmm.
and she told them that she didn't know who the father of the child was.
Ooh.
And the registrar just said to her, are you married? She said, yes. Give me your husband's name. So obviously, the law is couched in such a way that regardless of whether
Okay.
you don't know whether the child's father is your husband's or not, the child belongs to your husband. And so under section 59A of our British Nationality Act, if at the time of the child's birth the child's mother was married, then automatically that husband is the father of the child. You see,
So
I was
what if, yeah, so what if the husband
saying,
um is not accepting the child? Would it be
it's not
forced on him because he's married to the woman, to the
it's
wife?
not his decision to make because the law says that it is his child. So unfortunately, it's not as if he has a say in the matter. So unfortunately, he does not have a say in the matter because, like I was saying, our laws are very traditional in that sense, and so it would mean that the child's mother, even if she did something out of wedlock, they wouldn't want the child to be seen as a bastard child.
Right.
So
So it's for the interest of the child.
yes, yes, yes.
Okay.
So our laws are still very traditional in that sense, and it was trying to prevent that stigmatization, and therefore they have said if you were married at the time of the child's birth, then that child's father is the man you were married to. So this is not even just looking at how the child will receive his naturalization.
Mm.
By law, even when you are registering the child at the registry, they are going to take your husband's name. So it's not just to do with even the registration of the child as a British citizen, so that the child has
Ah.
citizenship
So
from
to the husband, whether you like it or not.
yes, that
Ah,
that
right.
child is your child.
Okay.
Yes, so right from birth on to them receiving their British citizenship,
Okay.
they say
Okay.
that it is their husband's child.
All right.
But if you are saying, well, in her case, she says she wants to get divorced. So if she's going to get a divorce and she wants to say that because this child was born outside of the UK, because obviously if they were born in the UK, they would have registered this child as the uh, child of the husband. But because she
Right.
gave birth to this child outside of the UK, I'm sure she put the child's biological father on the birth certificate. So if that is the case, she will then have to prove to them that it is indeed this other parent who is the child's father. So
Mm.
most of the time, it will mean that you have to do a DNA and prove that indeed the person that you say is the child's father is indeed his father. So
Okay.
once the DNA has been done, you can apply through registration for the child's father to be known as the one who the child will be deriving citizenship from.
Wow.
So um, you may still be married to somebody else, but you
Mm.
can still register the child to be British based on their biological fathers.
Right.
It has to go
Right.
through
Right.
a form of registration and then
Mm.
prove that is their father indeed and that he was British at the time of the child's birth. And then, of course, that child will receive their certificate for which they will be able to apply for a passport.
Okay.
Yes.
Right. On that note, Lawyer Eunice, I don't think we have any other questions. So, will you do us the honors by summarizing what we discussed so far for the benefit of those who join us at the latter part of this show? I will also advise those who joined us later that after this program, we will have a recorded version on our YouTube channel at BWF Solicitors. You sit down, relax, listen to everything from beginning to end. And if there's anything you need further, you know, explanation on or advice on, Lawyer Eunice will leave her details at the end of the show for you to contact her, and she'll be very happy to help. So, Lawyer Eunice, let's summarize everything and Remember to leave your details. People are sending messages. They need your details. So please do so as well.
Yes. So, yes, our topic today was just to make people realize how important it is to keep certain records, and also to know that unfortunately we don't have that automatic right to citizenship like in America, where you can say that you were born in the UK, so I'm a British citizen. Unfortunately, if you were born after 1st January 1983, you have no automatic right to British citizenship unless you can show that your parent was British or settled at the time you were born in the UK. If not, it would mean that you will have to show that if you were born outside of the UK, your parent was British, but they were not British by descent. And if it does happen that your parent was British by descent, you will still be able to meet certain requirements under our British Nationality Act, but you will have to either register or gain a right of abode to be able to come to the UK. And if for any reason you had this child out of wedlock, the British Nationality Act obviously does not want any child to be seen or stigmatized as a bastard child. And so, any child who was born to you at a time when you were married is the child of the husband you were married to. If it is not so and you are saying otherwise, then you will have to prove the paternity and then register this child to be British on the basis that their biological father is British. And so
Mm.
maybe the topic today has nothing to do with your issue or your circumstance. If you have any other issues, not just in regards to immigration, maybe it could be a family issue, maybe it could be a molestation issue, it could be that somebody owes you and you want you to be able to get what is yours. Or you are looking to have your will drafted, because I don't believe that wills are only for people who are going to die. I think that, of course, if you believe that you want to leave something behind for your loved ones, you can get round to drafting a will. We also do or offer such services at BWF Solicitors. We are in London. We are on the fourth floor of Anna House, 214 to 218 Tottenham High Road, London, and our postcode is N15 4NP. So N15 4NP. Our telephone number is 0208 493 7340. So 0208 493 7340. And if you want to contact me out of office hours, because we open from Monday to Friday, 9:30 a.m. to 6 p.m., you can call my number, which is 075 35 81 3910. So it's 075 35 81 3910.
So is it a 24-hour hotline?
Well, we would like to say that it is one, but unfortunately, we do like to also have a bit of a rest. So it's not a 24-hour hotline. But if you do call us out of office hours and we see your missed call, we will give you a call back.
Yeah. The reason why I'm saying this is, even as the host of the show, we put the studio number,
Oh yeah,
on the screen. I do get, calls late in the night,
yeah,
and
yeah.
I do tell them that I'm only a host. I'm not a solicitor to give an advice. Please,
Oh
can you contact Lawyer Eunice on, so and so
yeah,
number, but please don't call
yeah,
late.
yes, yes, yeah,
You see,
yeah,
so I also do get that, phone
yeah.
call, but I don't mind. But the fact that they feel The
Yes.
phone lines are still available for them
Yeah.
to have a discussion or seek advice.
Yeah.
I'll just, send them your contact details, and also mention that call Lawyer Eunice between 8 to 6. If Lawyer Eunice
That's
would like
true.
to speak to you later on in the evening, it's between you and her. But
I know,
that is
right?
it. Yeah.
And I guess people call at a time when it's convenient for them.
Exactly.
So when
Exactly.
it's
Exactly.
most convenient for them, then
Yeah.
they do
Yeah.
call.
Yeah.
Unfortunately, with lawyers, we are not like doctors where we work 24/7. So if we do see your missed call, we will give you a call back
Definitely
on.
call you back.
Yeah.
Yeah. I understand some people, will need to speak to a solicitor urgently, especially if you've been apprehended or taken away to the detention center. They
Yes.
need to speak to a
But that
solicitor
will be
as
during
soon as
the day
possible.
because they don't even work in the night
Oh, is
hours.
it?
Yes, they
Oh,
don't work
all right. Okay. I haven't
in
experienced that before, so I thought
no, 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 no.
it's
It'll be
24
during the
hours. You
day.
can be, taken to detention late at night, in the evening, and you might need to speak to a solicitor to
Oh,
stop deportation.
yeah. The
Yeah.
airports have a closing time. They don't
Mm,
entertain such things at night. So
mm,
they would definitely be doing that during the daytime. And especially you would
right,
see that early
right.
hours in the morning, that's when you get such calls. Yeah.
Calls. All right. Okay. All right. So on that note, we bring this show to an end. I believe that you've learned so much from this topic. And I will also advise you send, the recorded version to all your contacts. I believe this, discussion will benefit
Yeah.
someone. Like the lawyer Eunice said, if you have any further queries, she's left her details for you to contact her. So thank you so much for staying with us through the program. Those of you who joined us at the latter part, don't worry, as I said, you can watch a recorded version on our YouTube channel at BWF Solicitors. Anyway, we appreciate you, we adore you. Without you, I don't think this show will go as far as it has been. So thank you so much. And thank you, Lawyer Eunice, for taking time off your busy schedules, family duties, and
Yes.
coming to do your bits for the community. We do appreciate you and your team as well, especially Lawyer Ben. So thank you so much. We'll see you again another time. Bye bye.